to everyone to this first workshop in our series in this semester and in the new year of 2021 on artificial intelligence and the law. This is a series that we've had for a couple of years now. This year is extra special due to the pandemic. Everything is being done virtually. It would be great to see everyone in person the way we did last year, but that may have to wait a few weeks yet. And one of the areas, we'll be looking at a number of different areas of the law, the way that intersects with algorithmic systems, with artificial intelligence and machine learning systems. One area where we're already seeing the deployment of these kinds of actuarial or algorithmic systems is in the criminal justice system. And so we are really excited to have with us as our first speaker for the series this year, Professor Jessica Eaglin, who comes to us from the Maurer School of Law at Indiana University, Bloomington. She's been doing some extremely interesting research into the use of these types of actuarial systems in criminal justice. And today she will be sharing with us her work published in a paper called Technologically Distorted Conceptions of Punishment. We will hear from her for about 25-30 minutes summarizing the paper. The paper is also available to everyone through a link that was distributed with the advertisement. So hopefully some of you have had a chance to look at it. If you haven't, I encourage you to read it because it's well worth your time and effort. After we hear from Professor Eaglin, we will then hear a short responsive comment from our own Professor Kaaryn Gustafson. Professor Gustafson teaches and writes in the areas of criminal law and social justice and critical race theory, and is the director of the Center on Law, Equality, and Race here at UC Irvine. Sometimes is shortened to the acronym of CLEAR. After we hear from Professor Gustafson, we'll then open things up for questions. This is a webinar format, so there is a Q&A channel that people can post questions to. I will be keeping an eye on that to moderate the Q&A session when we get to that point. And we will take as many questions as we are able before we wrap up a little bit before the hour. I will also mention that this session has been approved for MCLE credit. So for those of you who are looking for continuing legal education credit, there will be a link posted in the chat that you can use to access for MCLE credit. And so with that, I would like to turn the time over to Professor Eaglin to talk to us about technologically distorted conceptions of punishment.
All right, thank you so much, Dan, and thank you to all of you out there in the ethers. It is a real delight to virtually be with you today and to get the chance to talk about this project. So as Dan mentioned, my name is Jessica Eaglin, and my research is, I'm really interested in technology and its intersection with mass incarceration. So we know that the United States has come to this point of crisis where we incarcerate about 2.3 million people on any given day in prisons and jails across the country. And in recent years, this phenomenon, mass incarceration, has come to the fore. And in a variety of ways, we see technology being introduced as a solution, or potentially the solution, of various kinds of technologies being introduced to respond to this social crisis. And my research is particularly interested in how that intersects with the realities of structural inequality and racial inequality in the United States, and the ways that that is reflected in the phenomenon of mass incarceration. So today's paper, Technologically Distorted Conceptions of Punishment, explores the social and historical context around the expansion of sentencing technologies. And so I describe in the paper, I'll talk about sort of the rise of technologies and the embedding of actuarial methodologies into those technologies that set a context, and in the paper I argue sort of are framed in a particular way that shapes our response to the expansion of technologies now, to understand them even as a response to mass incarceration. Um, and ultimately, in the paper, I argue that there are social costs to the expansion of technologies in sentencing that often go unacknowledged and are difficult to articulate, and that is in fact a function of technology itself, which is that the technology, the expansion of technology, has shaped our understanding of social concepts, and the social concepts are sort of the very concepts we use to critique the carceral state. And so part of the project is to say, as technologies expand, we need a more balanced platform to be able to talk about whether and when we should adopt technologies, actuarial risk assessments being the focus in this essay or in this paper, that allows us to think about the quantifiable but also the unquantifiable costs of adopting technologies as part of a response to social crises. So the takeaway from the paper, I hope, is nuanced in the sense that I argue that it's not at all clear that we should adopt actuarial risk assessments in this moment, although I think many would say that ship has sailed. I am a strong objector to that point. But I also think that the paper is a call for us to evaluate and expand our critiques of actuarial risk assessments from sort of their individualized impact to starting to think about their sort of social and collective impact on all of us, and the way that we understand social phenomenon, in particular, the crisis of mass incarceration in the United States. So the talk is going to proceed in three parts. I'm going to talk a little bit. I'm going to start by talking a bit more about what are actuarial risk assessments and giving some background on sort of the sentencing technologies that precede the introduction of actuarial risk assessments at sentencing now. And then I'm going to talk about the social concepts that have changed around actuarial risk assessments. Our ideas of what rehabilitation is, what racial justice means at sentencing, and what dangerousness and risk actually are, have all mutated with the advance of technical infrastructure in the sentencing process. And then I'm going to finish up by talking a little bit about what it means to reframe the debate, which is the ultimate aim of the paper, and how we can think about sort of moving forward in light of this history. So to begin, and actuarial risk assessments are, or the robust, I should say, the robust actuarial risk assessments that are proliferating at sentencing across the country, particularly in the states, are, as Dan sort of alluded to, we see actuarial risk assessments in a variety of places in the criminal justice system. And my critique, my analysis is narrowed to the context of post-conviction sentencing. So I am not even talking about pretrial, the pretrial use of actuarial risk assessments, which are also very popular, but particularly the expansion as a way to inform and guide judicial discretion in the determination of the punishment of somebody who has already been convicted for a crime. And what I argue in the paper, of course, is that that actuarial risk assessments as a sort of new invention or intervention is in fact quite old, in the sense that we have been embedding actuarial methodologies into the technologies that we have created at sentencing for now just about 40 years. And while these actuarial risk assessments are very different in some ways, the new risk assessments are very different, they are also a continuation of some of the very old sort of interventions that we have already seen. And so actuarial risk assessments in general predict the likelihood of an individual engaging in crime, whatever has been defined as crime, in the future, in a particular time in the future, based on statistical analyses of historical data on the behavior of the observed behavior of other offenders and whether they engaged in recidivism in the past. And it identifies, based on the statistical analysis of this data, objective, ostensibly objective factors that will predict the likelihood of somebody engaging in this behavior in the future. And then it is translated into a sort of tool of sorts. Today, sort of the hot way of talking about it is it's translated into an algorithm that will give you a standardized prediction. It'll tell you that, a statistical number that is usually translated into a sort of normative category. So somebody is medium, low, high risk. But earlier versions, and some that are very much still in use today, are based on sort of just sheets of paper, basically, that are checklists that say, oh, these couple of factors are present, and so this person is high risk or low risk, and sort of moves from there. And the idea is that this information is going to inform judicial discretion and improve the efficiency of their determinations, a judge's determination about whether to incarcerate somebody as opposed to placing them in correctional supervision in the community, the kinds of conditions that might come along with a punishment in the community as opposed to incarceration. And then, of course, the idea is that it's going to inform these individuals of sort of or make them aware of the financial constraints that we experience in this moment of expansive incarceration, to keep that in mind and to be more judicious, basically, in the allocation of our constrained resources. So the idea, of course, is that this information is going to help judges improve their sentencing practices. And in the paper, I say, well, this idea of introducing a technology to improve judicial decision-making in the response to a social crisis is not new, and that this is actually very much built upon the introduction of technologies starting in the 1960s. And what interests me is the way that not so much the technology, the design of the technologies have changed, but instead the way that we talk about the technologies has completely changed. And so in the paper, I talk a little bit about what I call the technological advancement narrative, and the ways that it is shaping discourse to make us focus particularly on technical aspects of the design of the tool. So does the tool include gender as a factor? Does it include race, which they do not at this point, as a specific factor? Are the tools more accurate than humans? Are they more accurate than older versions of the tools themselves? I argue in the paper that all of this is being shaped by a narrative that says, if technology can improve, then why wouldn't we use it? If it's better than humans, if it's better than previous technologies, then we should use them because they can continue to improve. And in the paper, I say, well, we've seen that sort of shaping legal debates, it's shaping policy debates, but that is actually itself constructed, and it's constructed in part by this sort of this building orientation around the technical aspects of technology as a response to sort of political crises. So in the paper, I start out by talking about, let's talk about the previous technologies. So actuarial risk assessments were first sort of embedded system-wide, embedded into sentencing processes, actually as a response to, or an ability to improve correctional decision-making during the rehabilitative era. So as I call the clinical rehabilitative era. So the 1950s through the 1960s, we see states across the country starting to adopt actuarial risk assessments to guide correctional officers in determining whether somebody needs particular treatments or services when they're actually being released, whether they are released or not from parole supervision. And what I argue is that this, while well-intentioned, the introduction of technology in that context was actually part of a sort of larger framing of the problems of sort of loss of jobs or the decline, the sort of stale job market that we don't often sort of hear about in the 1950s, but was already starting to rear its head. A framing of the problem of an increasingly racialized prison population, and the idea that we need some sort of justification to release people that is not rehabilitation, from the unfortunate assumption that Black people might not be as capable of rehabilitating as sort of the faith in white people or that had predominantly been in prisons up until about the 1940s, 1950s, and that this is sort of this also is an explanation that has nothing to do with sort of the accuracy of the technical design of the tools that sort of legitimates their presence. And then you move from there to the 1970s, where now we're in this moment where it's very sort of politically controversial to have faith in rehabilitation as an idea, as a guiding frame for sentencing and correctional policies. And you see the creation of parole guidelines. The federal system is the first to adopt parole guidelines that drop rehabilitation as a legitimate sort of justification when they create a decision-making structure, which are the parole guidelines, which are focused on crime severity and parole prognosis, which is supposed to actually be a replacement for whatever rehabilitation used to mean. These technical designers say, well, whatever rehabilitation was, we can now quantify it and say that it is this prognosis, which is sort of a stand-in for various different factors that rehabilitation sort of had captured, including amenability to treatment and likelihood of recidivating. And so what you see then is in the 1980s, we suddenly now there's an expansion of technologies again into the judicial sentencing context. So to guide not parole officers in their release decisions, but instead judges in their determination of an appropriate sentence for an individual defendant. We see again the federal system, but several states that create sentencing guidelines, which adopt the exact same model of sort of a decision-making structure from the parole guidelines, which embedded actuarial risk assessments in that parole prognosis. Now the actuarial risk assessments are embedded in our consideration of not the severity of the crime, but the offender's criminal history, which is supposed to be sort of the way we take into consideration individuals in this new sort of technical structure. And in the paper, I talk a little bit about sort of what's different about parole from parole context to the sentencing context, but everything that was different about the sort of adoption of criminal history and the infusion of actuarial risk assessments into that criminal history category is very constrained by sort of philosophical concerns, what I call human concerns, right? Philosophical concerns, and a concern that even if criminal history is going to have some sort of disparate impact, some negative impact on race and class marginalized populations, there was a certainty that that actuarial risk, sort of unbridled actuarial risk, would have that effect. Okay, and so what you see then is that from this transition, now suddenly here we are in 2020, and actuarial risk assessments have been proliferating since basically since 2010. For the last 10 years, they've been expanding in the sentencing context across the states as part of, not the only response, but part of basically most responses to mass incarceration in the states. So the idea is that if we can infuse actuarial risk assessments into judicial decision-making, it can be a way to reduce incarceration or the pressures of incarceration, the unnecessary pressures of incarceration anyway, and potentially improve or maintain public safety. Okay, but the question is, these tools that are proliferating now are completely unconstrained in the sentencing context, when we in the 1980s were deeply concerned about constraining actuarial risk assessments. And so the question is, what has changed? And in the paper, I argue that what's changed is not the technology, right? This is what the narrative, the sort of dominant narrative that's in this space is sort of focused on. The way that technology has changed, it's more accurate, it uses more data. And what I argue is that no, or at least maybe it's not a no, but there's something else that's changed, right? And those are our social concepts, and the way that technology fits into these social concepts that we use to critique and to sort of maintain faith in a functioning criminal justice system and a proper sentencing system. And so the first concept that I think is most pivotal in understanding as transformative is this idea of rehabilitation. Rehabilitation, whatever it meant in the past, was really grounded in ideas of reintegrating individuals into society. And that it was for the benefit of the individual. These technologies, right, we're supposed to treat individuals to help them reintegrate for their own value. And actual risk assessments that are proliferating now are actually being advanced on a very different sort of ethos, which is that it's for all of our benefit that actuarial risk assessments are being administered to these individuals, because it is going to identify for society, right, ways to save money, ways to reduce reduce recidivism, increase public safety. That this is a very different concept of what rehabilitation is. It's one that is much more grounded in behavioral modifications of the individual, and much less in reintegration into society. I argue in the paper that it is much more influenced by ideas of incapacitation than earlier notions of what rehabilitation were. And while, a sort of this change is not totally, this change can lead to some good, right? People can get treatment through actuarial risk assessments that are being administered. It also reflects this deeper change in our idea of what government is supposed to do. And this idea that the place where individuals should be treated is sort of legitimately treated through the carceral state as opposed to outside of it. And that has everything to do with the strategic response of rehabilitation scholars, and in response to the decline of rehabilitation in the 1970s, 1980s, their strategic response was to make risk, technical assessments of risk, central to rehabilitation. Our ideas of what rehabilitation is, and to disconnect rehabilitation from the idea of the welfare state. Okay, and so that's one way where our idea of what rehabilitation is really shaped by technology. And another concept that I argue in the paper is this idea of racial justice, that the introduction of technologies in the 1980s were offered, at least in part, as a response to the critique of racial disparities in sentencing and in criminal administration more broadly. And the idea was that sentencing technology, sentencing guidelines in particular, would be a way to at least reduce the occurrence of racial disparities. And in that sense, be a step towards racial justice. But unfortunately, the creation of technical guidelines had other effects. And I argue in the paper that some of those effects are our conception that what racial justice is the creation of more technologies, more technically precise sentencing outcomes, instead of a more substantive conception of sort of justice through sentencing practices, and a orientation around this idea of technology as itself being a sort of legitimate response to the occurrence of racial, or the evidence of racial injustice. And it's, unless we understand sort of our framing of sort of racial justice as sort of narrowly confined, we can't really grapple with the number of ways that people are now, legal scholars and others, are critiquing actuarial risk assessments as being as sort of embedding what I say in the paper, embedding structural racism, or reflecting structural racism in ways that are deeply problematic. So in the paper, I cite to two criminologists who say, how can we understand why somebody is high risk? Well, we can't, maybe it's because you are actually likely to engage in crime in the future, but it also is capturing, these tools are also capturing the likelihood that you live in a marginalized community that is over-policed, over-surveilled, and lacks sort of structural resources. And so, again, if, how can we understand that critique? We need to understand that we've already changed our ideas of what social justice means, what racial justice means, to incorporate technology, which is preventing us from sort of questioning whether or not to adopt the tools at all. And then my final argument, I'm not going to talk about it too long so that we can get to conversation, is that our notion of what risk is itself, what recidivism risk is much broader. We have this notion that recidivism risk is sort of analogous to or a one-to-one comparative with dangerousness, but it's actually not. And we once knew that sort of whatever this technology is measuring is sort of over capturing what is socially constructed recidivism, which is very much produced by law just as much as it's produced by sort of social contacts. And we've sort of disaggregated from that. And there's a flattening out of sort of the nuance of what recidivism risk might mean and what dangerousness means. So what does this mean for going forward? As I said at the beginning of the paper, my hope is that this is going to, that sort of illuminating this history, this idea that technology doesn't do just the things that we suggest it's going to do. It's not just going to sort of make humans better at making decisions. It's also going to change all of our conceptions of what criminal justice system is supposed to do, what is a legitimate critique of the carceral state. I think gives us a more balanced foundation to really question whether we want to continue moving in this direction. There are many different ways to address mass incarceration. Technology, actuarial risk assessments at sentencing are just one. And it's very possible that this is not one that we need to continue pursuing. But at the very least, we need to disaggregate ourselves basically from the constraints of this technological advancement narrative, which sort of prevents us from asking bigger questions about, why are these technologies being introduced in this moment? Why do we think that this is the way to respond to mass incarceration, as opposed to, the many other ways that might include not investing in the carceral state, but instead investing in, in sort of the social welfare, the social security net. So I'll leave it at that, and I look forward to the comments and to the conversation to come. Thank you again.
Thank you as well. Professor Gustafson, please.
Yeah, thank you. Thank you, Jessica, for this paper. I think it does a lot. It contributes to a number of literatures, which you note, but I think there are a couple of literatures that are also relevant and benefit from your analysis. And I'm going to focus on two of those in my comments. One is the anthropology of law, a literature with which I'm less familiar. And the second is sociological understandings of race, which I study a bit more closely. And I think one of the important parts of your paper is its contribution to the genealogy in shifts of understanding of rehabilitation. Right, and this is a very anthropological approach. If we think about law itself as cultural understandings or informed by and informing cultural understandings, but here you are tracing shifts in language, concepts, symbols, and general understandings of punishment and its purposes. And I think that's an important contribution of this paper. I think one of the more important contributions for me is the way this paper lays out the mechanisms of racial reproduction. And as I was reading it, it brought to mind Victor Ray's recent article, A Theory of Racialized Organizations. And Ray makes the point that, right, we tend to think about racism either on the micro level as interactions between individuals, individualized acts of racial discrimination, or on the structural level. And on the structural level, I think I'll reference Ruth Wilson Gilmore's definition of racism as the state-sanctioned and/or extra-legal production and exploitation of group differentiated vulnerabilities to premature death in distinct yet densely interconnected political geographies. But Victor Ray makes the point that there's something in between, that organizations and institutions often provide the mechanisms through which racism is perpetuated or is put into place. And I think that your article does a good job of showing just how that is done. So, right, it takes this meso approach, and especially part 3 and part 3B of your paper make clear that racism precedes the changes to the carceral system that you described going back to the 1950s, but that the system is perpetuating two processes that make racial inequality even more intractable. One is the expansion of mass incarceration. Second is this naturalization of racial inequality through sentencing, that we don't even talk about it once it becomes an abstract thing. That the language of risk removes sentencing from any discussions of justice. And so you can see this mechanism working. You describe it as an examination of how deified technological formalism reifies racial injustice. And I think that's a very important part of this paper. Race isn't the main focus of your argument, and yet it's such a strong theme throughout. Maybe because that's what I tend to study, but I see it in there, and I think as part, it's an important part of your contribution here. Now, the article is certainly an intervention intended to illuminate the problem of meso-level injustice and nudge actors toward a more careful analysis of what justice is. But I think that raises the question of where do we go? You raise a couple of things that prompt me to ask you more questions about that. So one is you suggest in the paper that more humanistic approaches are important if we are going to move out of this strict, narrow understanding of risk, and specifically risk of recidivism, of being attached to the criminal justice system again. And that has all sorts of implications about interventions needed on a broader scale, particularly in the welfare state. But the anthropological approach, right? That changes in concepts and understanding and symbols occur, suggest they happen slowly, and that means any interventions or pushback will also take a long time, especially since these understandings of risk now pervade the way the parole system approaches punishment, the way the sentencing system approaches it, courts, and the public. And so, how do we then make a shift back? Clearly, your paper is an effort to say, look, right? Look behind the screen. There's something more going on. But how do we make those changes? And what are the humanistic approaches that are important to coaxing people into broader understandings of of risk and an adoption of rehabilitation and a deep understanding of rehabilitation as a possible model. So thank you again for this paper.
Thank you. Can I respond to that?
I hope that you will, please.
So thank you. Oh my gosh. I mean, I've had the opportunity to engage with Kaaryn in the past, but you read my research agenda. You might as well have just read it out, directly. So, thank you so much. I think that, these 2 points that you make, particularly about the intervention to sociological studies of race, that's very much what I see my work is doing. I know it's a part of my projects up until now. I have not always sort of put the race aspect of the analysis front and center. But I do think that this question you raise about sort of the sociological construction of race, that's what I'm really grappling with now. And I think, honestly, we cannot think about that without thinking about the carceral state, and sentencing is the place that I sort of enter into that. So thinking about, just as you said, thinking about sort of the way that we are literally producing racial meaning in transforming sentencing. And I think, truly, I don't know if it comes out as much in my comments, but I try and emphasize this in the paper. I think that oftentimes, these technical reforms are adopted, well-intentioned as sort of a way to sort of to do something. At least, there's at least some sort of intention to reduce racial disparities. But I do think that it's, part of it is this, we can't understand these technologies without understanding, the context of sort of the turn away from, or the crisis of confronting race that we have existed in, sort of, at the end of the 20th century, and that we find ourselves in now. And so part of it, I do think, is saying, we've got to be able to start talking about race and in ways that actually the carceral state, sort of depoliticizes. It makes it very difficult to talk about racial justice and to talk about racial justice, not just in the carceral state, but as you said, thinking about it more broadly as a sort of agenda, and thinking about what kind of society we want to live in, right? So thinking about this question of this connection, I love the way you said it, this connection between the anthropological aspect and sort of the sociological aspect of race. When it comes to sentencing, and you and Dan have sort of seen the next project that I have on this, what I argue is that, really we need judges to be, active thinkers. And what I see the technology is doing is making judges or inviting judges to be passive thinkers, to say, oh, the technology told me, the guidelines told me what crime severity is. The actual risk assessment told me what recidivism risk is. And instead of and maybe a first place, the sort of to the happen slowly question, a first step is to see the courts do a little bit of the sort of deep critical thinking that we've seen in some of the sort of more unique cases. Around mandatory minimums and around some of the more structural critiques of sentencing guidelines, which is to say, point out that these guidelines and actual risk assessments embed structural marginalization right into them, and have a little bit of doubt, deep skepticism that responding through more incarceration, more carceral supervision is the way to respond, and that it can't be. I think part of what the paper is trying to grapple with is that it can't be sort of a starting from an individual perspective that one person or even one group of people can say there's something wrong with the carceral state, there's something wrong with sentencing. We all really need to start to sort of ask, like, what are the things that we ask judges to do, and what are the ways that the things we're asking them to do are things that we don't have to ask them to do. There are other institutions that we had that have existed or that can exist that can do some of this work, and so I think that that's a big step here. And at the end of this paper, I highlight, I think the example of like the North Carolina Sentencing Commission piercing the veil of the sort of technical aspects of actual risk assessments and saying, we don't need actual risk assessments. Everything you're asking us to take into consideration that is legitimate is actually already considered in the existing sentencing technologies that we have, is a very small step, but it is a step by saying, maybe the problem is not technical. This is not, we don't need more technical solutions. We need sort of more sort of socially oriented interventions. And so that is a very, very small step. But I think that it doesn't have to mean, a wholesale sort of tearing down of the system. I mean, I say in this paper, like, all things being equal, I don't think that we need more actuarial risk assessments. I really don't. But I also don't think, as people argue, maybe they are here to stay, but that the way we think about what they're doing has to be the first step to sort of critically engaging with their expansion and what their expansion means in sentencing and criminal administration more broadly.
Okay. So we're starting to get some questions come into our Q&A channel, which is great. But I selfishly am going to grab the moderator's prerogative to ask my question first. So I'm fascinated by the paper and really interested in what you call the technological development narrative, and in particular what you say about the conversation around accuracy, right? Is the extent to which accuracy is discussed. So it makes me think about some work that's been done in the sociology of markets. People like Donald McKenzie looking at the use of actuarial and risk assessment tools in financial markets. And the argument that they make there and the conclusions they draw there are that these types of algorithmic risk assessments in financial markets, they create an illusion of certainty, right? They allow you to make an assessment of something that otherwise couldn't be assessed, which is the risk in the future. Make a prediction about the future, and that then allows negotiation and discussions to begin that otherwise wouldn't happen because it would be uncertain. So there's this illusion of certainty that is a focal point or a starting point for conversations. I wonder if you see that happening in criminal justice, if these types of actuarial systems are creating an illusion of certainty or a promise of certainty that is the focal point for discussions. And what are those discussions? Maybe they're the wrong discussions, and what should they be?
Mm-hmm. I love that question. So, just for others that are joining, a previous project that I wrote is constructing recidivism risk. And I was really fascinated with sort of how we design the actuarial risk assessments that are used at sentencing. And I was frustrated by the ways that anytime I asked a question, I felt like every time I met up with a question where I said, well, normatively, why, like, why would we include gender? Why do we include, why would we include something like zip code, for example, which is, something I highlight in the paper and I come back to a lot, where actually a lot of these actuarial risk assessments do include zip code as a predictor of recidivism risk. And I think that it is just sort of the unbridled example of the ways that the tools are capturing something very different, structural marginalization. If somebody is at risk because they live in a particular neighborhood, that is deeply problematic. And that's not something that should enhance, in my mind, that's not something that should enhance somebody's sort of likelihood of being exposed to carceral supervision. But I think that, to Dan's question, that conversation is stifled by the accuracy, the discourse on accuracy, where, the conversation becomes, well, if the tools are accurate, then, if we can make them more accurate, then either that person, that individual should or should not be, under supervision, or, we need to think about novel ways to sort of intervene, that are, and then you get into this big discourse that's going on now, but about fairness and, whatever we think fairness is in the technical context. But I think that Dan's question is quite right, where if we accept, if you can't engage with the technology, you can't engage with sort of the ways that we think about it, then you are at a downstream position where you say, well, the problem is then how we respond to what is, whatever, an accurate assessment of recidivism risk. And it leads to, as something I've talked about in another project, the expansion or the potential to expand carceral supervision for people who otherwise would not have been put under carceral supervision, because now they are subjected to, they've sort of been categorized or classified as somebody that is at risk. And you see things, so you see things like the expansion of electronic monitoring, the expansion of day kiosks, these very small, it makes me think of, oh gosh, I'm going to blank on the name, Erin Murphy's, The Paradigms of Restraint. I just love that project. I think it was from 2008. And she's sort of one of the first scholars, I think, to really talk about, when we have this frame of, sort of everything's better than being incarcerated, we miss the ways that all these small interventions that, if the tool is sort of accurate, maybe it legitimates, like, let's, oh, it's not that hard to go check in at a day kiosk, once a day or once a week, every week, going forward. It's not that much of an intervention, but the ways that, again, going to this point, I think that Kaaryn was making about sort of the sociology of inequality, that those answers have deep implications for continuing and entrenching marginalization and vulnerability to the carceral state, that I think that the accuracy debate is it sort of mutes it sort of answers questions for us that I think should not be answered, that should be debated. And thinking about, I also really enjoy the way that you pose the question, Dan, because I think it highlights something else that is sort of a bone I have to pick with actuarial risk assessments in criminal administration, which is this perception that that we can adopt the same sort of frameworks from different contexts, even in criminal administration, but particularly from outside criminal administration, and have them do the same work in different contexts. So, you're saying, in the sort of financial markets context, okay, we care about risk, and that's how we make decisions. But in the context of criminal administration, that really, we're asking a completely different question. We're talking about, it's just a very different framework, and we should be asking what each of these frameworks are meant to do. And I very much, am not sort of giving the green light to the way that we allow, accuracy to shape discourse in other contexts. I think of a former colleague of mine who's done some really great work thinking about, sort of the legal regulation of the financial market, and the introduction of technology, and sort of the ways that has its own perversions. But I think that in that sense, it really highlights how criminal justice, I think, or the expansion of actual risk assessments are so controversial in the criminal administration context because it's a place where they're in some ways sort of least sort of naturally cohesive. And it's part of the reason why I don't talk about them in the pretrial context, because pretrial is much more sort of, the aims of pretrial are much more forward-looking and have their own sort of unique concerns that in the post-conviction context, are not quite as prevalent, or not, at least not as beyond debate. And so to see the expansion of the tools in both contexts really illuminates that it's something going on with us in the way that, it also makes me think of Ian Hacking's work, right? Like the idea that the interest in probabilities itself is socially constructed. It is, a thing that is responding to our particular social context. Is deeply important to remember, I think, in this moment, and highlights again, I think, hopefully part of what the work of this paper is doing, which is saying, we've got to look at that social context to understand it's not just about, our increasing capacity to manage large amounts of data. It's about, sort of at least in the context of post-conviction sentencing, I think it's about a deep structural insecurity that gives us a structural insecurity in society that gives us sort of an enthusiasm for expanding technologies in this context, or at least in this way, maybe is the way I'd say it. There's lots of ways to use technology, but the way we're using it now is reminiscent, or it resonates of a particular kind of social response.
Yep. So the first question, our Q kind of follows up on the accuracy question. It says, how do you know, how do they even try and measure if this is accurate or not, if that's what we're talking about? And if someone who's high risk is not released, so they can't become a recidivist, doesn't that skew the sample, or how would you know if in fact your assessment was correct?
Yeah. So thank you for that question. So it's fascinating to me because, so right now in the context of actual risk assessments in criminal administration, there's a huge debate about, what metric is the quote unquote right metric, the most fair metric for us to assess the accuracy of a tool. And this again relates deeply, or has played out in the context of race, right? Saying that, if you'll recall, there was a debate that started out with ProPublica saying that Compass, a very popular actual risk assessment used at sentencing, is racially biased, and they used one particular metric that was based on sort of failures, like do you have the same amount of inaccurate or failures of the commission of recidivism. So you said people were going to recidivate and then they didn't. Is that the right metric for Black defendants versus white defendants? And they said, well, no, there's a big difference on that context. And then you saw from the developers of the Compass tool, Northpoint, saying, well, actually, the metric that we use is do we get it right the same amount of times? And so, that somebody who commits, we predict somebody that's going to commit a crime in the future, and they do, that's consistent across races, and that's the way we should define accuracy. What fascinates me is that actually this metric has changed. Sort of the gold star of how we measure accuracy changed, and in the paper that I referenced, Constructing Recidivism Risk, I talk about that. And that, it changed very recently, actually. I mean, relative to sort of the history of actual risk assessments, that there was a shift, and that shift has, deep normative implications. In my paper, I argue, I think that there's sort of good and bad arguments to both, and we should be incorporating the populations of people who are most affected by actual risk assessments and sort of trying to decide which one of those metrics we might want to guide our sentencing decision making. But certainly that there are sort of different ways that you can respond, and that people are sort of reading in their own normative judgments about which one of those metrics should be the metric that guides us in this moment. Okay. So then there was another question. Dan, do you want to briefly re-summarize the second part of the question? I'm sorry.
Well, so there's the next question that we have is pretty interesting. It asks, can you reorient the technology, right? If it's a problem to have actuarial assessments of recidivism, what if you tried to have an actuarial assessment of a prediction about what the individual needed for rehabilitation? Would that be a more productive way to use the technology, or would that cause other problems? Can you can you rehabilitate the technology?
Yeah, so I think that that's what a lot of rehabilitation scholars have done, right? And it's one of the really interesting things about sort of the genealogy of actuarial risk assessments is that, it started out, I didn't go into it that much in the talk, but I mean, it started out, actual risk assessments started out, and they were very controversial as part of this sort of trend towards selective incapacitation. And the idea was we are going to identify people who need to be incarcerated for longer, but at the same time, you had rehabilitation scholars working in their sort of, sphere, trying to rehabilitate rehabilitation with the technology and incorporating risk assessments into that. And that's part of the reason why there's such sort of disparate conversations in this moment about actuarial risk assessments, because rehabilitation scholars have offered this as saying, like, don't use it in the way that is going to identify people for more, carceral supervision. Use it in the way that will, identify people or identify needs, the risk and needs sort of framework that can be offered. And I think, my project is sort of saying we can't contain it. If you think you might think that it's being offered for this particular purpose, and for a lot of reasons about sort of the history of changing sentencing processes, we want judges to be able to sort of consider those technologies. But just as much as they're going to use it for rehabilitation, they're going to be influenced by sort of the changing conception of what rehabilitation is that isolates it from sort of these larger transformations in our sort of social welfare structure. But to this question of, can we use the technology for good? I think that we definitely can. And I've seen some really interesting work. It makes me think of Andrew Guthrie Ferguson, who suggested, maybe the way we use actuarial, assessments is trying to identify, I think it's in his context, he says maybe identifying cops that are at high risk of sort of engaging in dangerous activities, and use that as a way to really rehabilitate them. It makes me by through sort of training and et cetera. It also makes me think of Sandy Mason has in her recent article, Bias In, Bias Out, she suggests using actuarial risk assessments as a diagnostic, as a way to sort of identify different problematic policing practices, which I think is very interesting. It makes me think of Ruha Benjamin's work, where she identifies a lot of ways that that algorithmic technologies can be used to sort of disrupt the production of racial meaning, in not just in the carceral context, but outside of it as well, as ways to, as I've sort of said in a paper recently, as ways to sort of critique and make us think about sort of the structures of society, as opposed to individualizing to identify individuals for carceral supervision. So I think there's lots of ways to use technology. And again, I think it goes to this point that I made in response to Dan's question. We choose to use the technologies in a particular way that is based on our own social sort of experience. We want these tools to be used to sort of enhance sentencing decision-making for individuals. And that has everything to do with us and not really anything to do with the technology itself.
Okay, well, that sounds to me like a fabulous place to wrap up. We're coming down to the end of the hour. Let me again call people's attention to the links in the chat. One link to Professor Eaglin's paper, and another one to the MCLE if you're looking for MCLE credit. Let's give a big round of virtual applause to Professor Eaglin and to Professor Gustafson for this session. My students, I will see you in about 10 minutes in our virtual classroom. And to the rest of our audience, I hope you'll join us again on February 8th for the next speaker in our series, which will be Professor Frank Pascale from Brooklyn Law School. Thank you for being here. And thank you again, Professor Eaglin.
Thank you. Thank you so much. It's a pleasure to be here. Thank you, Kaaryn.
Thank you, Jessica. This was great.
So fun. Such a
Talk to
fun
you soon.
conversation. We'll have to keep it going.
Good, good. Okay.